Good evening, everyone. All my colleagues, brother advocates. It's been a tough time through which the entire world is going. COVID 19 has affected us like anything. Our courts have been virtually shut since 15th March 2020. Since 24th March, it has completely got down. We, the lawyers who have been used to of living a life of going to the court early morning, reaching, arguing, rushing from one court to another, all has come to a standstill. One corona has affected the entire thing. These are unprecedented times. We all are suffering. During this time, I was wondering, what are the things that can be done and that should be done so we can come and deliver what we know the best, the job as a lawyer, as an advocate before our honorable court. Honestly speaking, I was extremely disappointed when everything else was opening up but the court. I used to feel that the Delhi High Court should lead the example to the country, and therefore my disappointment was galore. But when ordinary man sleeps, the wise man wakes up to make things brighter for the society and for the people. And when my disappointment was at its fore, I came across the rules that was laid down by the Honorable High Court of Delhi. Only on 1st June 2002. This rule is called Rule for Video Conferencing for Courts 2020. This has been done by the Honorable High Court in exercise of power under Article 225 and 227 of the Constitution of India. Now these rules are not only comprehensive in its detailing, but also taken care of each and everything which is otherwise being put against the use of the virtual court system. I think before understanding the solution of anything, it is important to understand the gravity of the problem which we were facing and the solution which has been provided by the Honorable High Court of Delhi through these rules, which I am going to lay before you. So in the pre-COVID time, Honorable High Court of Delhi used to take care of about 1,000 cases per day. I casually took out the cause list of 7th January 2020, and a very bare calculation of the same led to me to see that there were 846 cases that were there on the business. A staggering figure. Subsequently, the COVID has been announced, the lockdown has taken over, and the Honorable High Court of Delhi were taking only exceptional cases. And if you take only the exceptional out of the exceptional cases, the number of the cases are going to be down by miles, as evident from the figure which I am just sharing with you. On 15th April 2020, 21 cases were listed on the board through video conference. Of course, neither we are used to of the video conference nor the judges, I may say so, sir. As the use grew, so is the number of the increase of the listing. So it got into 80 cases about on 1st May 2020. In the meanwhile, the High Court has rose to the occasion and it has started working with full strength. And as on 2nd June 2020, when I am recording this, as I have understood from the cause list, there are about 118 cases which are listed. Now, if we see 118 cases listed as an emergency or extraordinary cases, and that too through the medium of the video conference, and put it with a figure of 7th January 2020, what we see are a stark dip in the access to the judicial service or the legal system by the commoner. How many rights are getting affected by it? That's a fundamental question. Now, this being the situation with the High Court, Delhi is divided into 9 districts and we have 6 courts to cater to the need of the ordinary people. That is the court at the first side. This is the court of the original jurisdiction, generally speaking, whether it is on the civil side or on the criminal side. A very rough calculation. There are about 400 judges in all these 9 districts across 6 courts in Delhi. And if I just put it at an average figure of only 40 per judge per day, so I am looking at a figure of something 1600 to 1800 kind of a thing, which used to be the rate of the dispensation prior to the COVID time. We spoke a lot about the pendency of the cases, and I'm sure these 3 months would have only added to the bulk and not reduced it. And therefore, there was the definite requirement of having it. And our Honorable High Court of Delhi has done it. Some may debate it, that it came little late, but I say it's better late than never. And here we have. Before taking you to the technical nitty-gritties of the rule, why it is important, let us understand how does it actually work. Is it that difficult that it is confined to only few, as many people in the bar councils and the associations have been arguing upon, or is it something which is far more easy? I bet you, if you have been using a smartphone, and if you have been using it for some time and using the Facebook, using the Instagram or the email or the WhatsApp, then the process of virtual hearing is as simple as that. It's just a mindset. Put it aside, enter into the zone, see and feel the difference. Now I'll take you to the process for a better understanding so that you can understand it. All you need is 2 things, and I'm sure most of you would have at least one, and therefore you are watching me today, now, here, which is your mobile phone, the ultimate machine and answer everything to all your needs. If you are a user of Android phone, all you need to go to Play Store, just type it on the search button, Cisco WebEx, download it, as simple as you have done the Facebook Lite version. Having done that, you are now half prepared to take the journey forward. Trust me, this simple step has solved half of your problem now and here. Then you can create your ID, make your names and all that configuration. As soon as you get into any app, you know how it functions. They make it so simple, so you go through with the flow and not for any other reason. Now, similarly, the iPhone user can go to their Apple Store, again type Cisco WebEx, and that's there. And trust me, I am not here advocating or wooing for the Cisco WebEx, or I am not against Zoom. This rule has provided that there would be a designated software which will be used for the purposes of the video conferencing, and therefore this name is set. And why I am using the Cisco? Because yesterday I had a hearing in which the Cisco WebEx was used. So I am presuming it is that designated in the licensed software through which virtual court would now run. Now, how does this whole process work once we have installed it? It is as simple as that. There is one simple application, the format of which is already provided in the rules in Schedule 2. You just have to make a request through that particular form in Schedule 2. That will go to the concerned court. The concerned courts will like to hear your matter. There is a requirement. It is desirable that you contact your opposite party, get their consent for it. We understand in adversarial matter, in adversarial form of litigation, it is not possible to have the consent of the opposite party for reasons we in the legal community knows as good as the judges would know it, I'm sure. So even if the consent is not given, the same fact can be intimated to the learned presiding judge. And once you're there, so now how does this work? The whole structure is made in such a way where there will be 2 points. One is the court point, other is the remote point. These are the 2 terms which are precisely used in the rule which I am referring to. Court point refers to where the presiding officer would be sitting and operating from, and the remote point is where the lawyer or the witness or any other person as may be necessary for the purpose of the proceedings would be there. So now there are 2 points. One is the court point, other is the remote point. Now in order to assist the court or to facilitate its working, there will be a coordinator who can be called as a court coordinator, and also to facilitate the work of at the remote point there will be another coordinator, and these coordinator will set up the whole thing into motion. Now once your request is there, the court will have the initial hearing. I am assuming that the other party also comes in that hearing. If it comes, then the hearing may start on that day at that particular point of time, or on that day the court may give a specified time. Generally, I think the court is going to prefer the latter option for the smooth functioning and the easy availability and the exchange of documents beforehand through the digitized medium. Now once a date is fixed, say 15th of June is fixed for the purpose of the hearing at 3 p.m. So on that day, it is the mandate of this rule that the court coordinator and the person who is at the remote point, the coordinator, will make themselves available at least half an hour before the session, actual scheduled time. Now this is the time given for the parties to see off if there are no glitches, the technical glitches of course I am talking about. And then there is also a provision that says it is desirable that the parties go through the testing of it. So within half an hour you can walk around everything. Now I said then only one thing, which is the requirement of the mobile. The other thing which is more relevant for the entire purpose is a stable network. A decent speed can make this happen because this doesn't consume too much of a data. So on the scheduled time, coordinator, the concerned person appearing in the court, be it the lawyer or the witness or any other person, and so is the coordinator from the court point, need to be ready with their device, which in this case I am only referring to mobile, and with a stable internet. The court coordinator will be sending an email with a link inviting you for the meeting. Do not worry if you are not accessing email. You can receive the link on your WhatsApp as well. All that you have to do is to click it and you will reach to the meeting room. Initial half an hour would be spent to see everything is going through. After that, the official session would begin. Parties are required. Everybody is required to put their phone on a mute position, and only when the judge says to the concerned lawyer who can hear the voice of the judge will then speak up. And trust me, within 3 minutes into the session, you will fall into the same zone as that you do in the court. Trust me, 3 minutes into the virtual hearing, you will forget the difference between the virtual and the real, as you do in the court. 100 people sitting at your back, you don't care. Many voices distracting you, but you are focused on two things: the brief and the judge. Mindlessly or with full of mind, reading their mind. That's how we do in the court, and that's how we try to strike the gold for our clients. That's what we are paid for, and that's what we should do and we must do. Now, once the hearing is over, you will get the order through email about the things. Now, while drafting these rules, the courts had already enough experience as to the basic problems which were being faced by the people coming in those urgent hearings. That is, loss of connectivity, loss of transmission. Here, if it so happens, then it is provided that as soon as the hearing is over, or at the earliest possible time, you need to put your grievance to the court coordinator. And the court coordinator, without wasting a time, will go to the judge and inform about it. The judge himself being present, adjudicating, would know what has gone. He will have three choices to make. One, to order for a reschedule of a meeting, or to declare the entire proceeding as non-est, having that it has not happened at all. And the third is, the court may think that the submission which is so made by the applicant is absolutely not maintainable, being a way to gain more mileage or being an afterthought. So this is how beautifully this entire thing has been done. So far, the courts were looking only two kind of a thing. One is extremely exceptional cases, and in the case of the High Court, they were also inviting the people for some time to do the final arguments, prior to that exchanging the written submission. But this rule that I am talking about, which has been laid yesterday on 1st June 2020, it talks about appearance, evidence and submission. So it encompasses all the three stages of a trial, and that's why I say, now I am sure you are now armed with the very basic of the rules. That is how it is going to be implemented. Now, in order to appreciate the entire rule better, I will just rush through, understanding the importance of time to all of you. I'll just rush through the rules. So this rule shall be called as the High Court of Daily Rules for Video Conferencing for Courts 2020. Part 2, as happens in all the rules or the acts, is about the definitions. I will straight away take you to clause 2, subclause 4, that defines what does court here means in the rule. And court here means includes a physical court and a virtual court and also a tribunal. So the court is physical court, the virtual court, or the tribunal. This is the extent of this. Clause 2, subclause 8 says that this rule is not drafted only for the present situation or the condition, but for all the situation and the circumstances that we may, God forbid, encounter ever in times to come too. As I said earlier in my introduction, there are two words which are used. One is remote point, another is the remote user. 2 clause 10 defines remote point is a place where any person or persons are required to be present or appear through a video link. And who a required user is defined under 2 subclause 12. And here once again, if we look into the definition of it, who are included in it? The person who is to be examined, the person in whose presence certain proceedings are to be recorded or conducted, for example in a criminal matter, an accused, an advocate or a party in persons who intends to examine a witness. So mind you, this is not limited only to the arguments at the earlier stage or at the final. This covers the entire ambit of the evidence which is being subject to a lot of questions. How the virtual court will replace the physical and the actual court when we talk about the examination. And any person who is required to make submissions before the court, for example, the expert witness, any other person who is permitted by the court to appear through video conferencing. So this has a lot of things. Now the chapter 2 that deals with the general principle, section 5 says what does this video conferencing facility would include. So it says in 3 clause 1, video conferencing facilities may be used at all stages. Mark these words: at all stages of judicial proceedings and proceedings conducted by the court. And then to further clarify, it is stated that all the proceedings conducted by a court via conferencing shall be a judicial proceedings. And all the protocols need to be maintained the way we do in the physical court or in the actual court, that we have to be in the appropriate robe, that is the black coat with a white band that we always wear, and have to adhere. And court has seen during these exceptional times across India the kind of the problem faced, and therefore it laid down in schedule 1 the protocols which required to be maintained by everyone who is participating through the video conferencing. The entire set of laws would be applicable, whether it's CPC, CRPC, Indian Evidence Act, or the Information Technology Act. And a provision is given where it is said that the power to amend is there, and it can be done from time to time, because the experience is going to teach us much. Although this is comprehensive, yet it can be made better by having this clause. Also, not only the court that can conduct the proceeding through video conferences, also the commissioner can do it so by virtue of provision 3 clause 4. 3 clause 5. As in the court, so through the virtual court, unauthorized recording is not permitted. It is also the mandate of the rule that the party who comes here has to show their identity card, as issued either by the government of India or the state government or the union territory. And so such is the flexibility of the rule that if somebody is not carrying the I card, or he or she may not have it, then that person can give an affidavit. And then clause 4 basically talks about the kind of the facility which is required to be there. So they talks about the desktop, laptop, camera. I think it is too easy for all of you to go through it. Do refer to clause 4 and you will have the understanding. Now such is the thing that in clause 5 of the rules preparatory arrangements have been defined. So for example, if somebody is doing a video conference overseas, who will be the coordinator? This rule says that the coordinator will be the relevant High Commission of India or any person authorized by it. Similarly, in case of a jail, who would be the coordinator? The jail superintendent or officer in charge will be that. Forensic science lab, the administrative officer in charge. Now, if I go further, then there are few things which are also mandated in clause 5, essentially in 5.6. As I said earlier, unauthorized recording is not permitted. It is to be ensured that the witness or the person who is deposing before the court is neither prompted nor tutored, coaxed, induced or coerced in any manner by any person. The rules also provide that in case the evidence is being done and the witness is to be confronted with the document, it is desirable that the digitized copy shall be made available to the coordinator at the remote location where the witness is, and if the court grants the permission, then such witness can be shown that digitized version, and then the examiner can ask the relevant question, and the exhibition of the documents or the marking of the documents can be done at the court point by the coordinator or as the court may deem fit. Further, it also provides that immediately the certified copy need to be provided, and it also talks about the provision of providing the facility of a translator, an expert in case a person is disabled or unable to hear, or an interpreter. Procedure for video conferencing is provided under chapter 3. Any party can make a request. It is desirable to have the consent. Then clause 7 talks about the service of the summons. During the COVID time, service of summons through the ordinary mode is difficult, and it also looks paradoxical if for a virtual conference we do the summoning through ordinary mode. Therefore, the permission to serve the summon through WhatsApp or email is permitted, rather provided for. Then I am just not going into the clause 8, self-explanatory, and one can go to it, or I can come back again in detail and seeing how 8 and 9 talks about the way of the cross-examination or the evidence to be done, how the documents need to be digitized and all this thing. Then I am coming straight away to clause 10. It is ensuring seamless video conferencing. Now 10.1 says the requirement of a coordinator at the remote point is only in case the witnesses are to be examined, and it is not applicable in other cases. So that is very important for us to understand that as a lawyer I can appear. I do not, the court doesn't require to provide for the appointment of a coordinator at the remote point. And as I said earlier in my preface, that it is the expectation through this that parties should join half an hour earlier. It is imperative upon the court that it shall record on the order sheet the time of the start of the video conference, the time on which the particular hearing or the examination gets over, and then at the end it should also write the total duration which has been taken care of. It is also mandated upon the court as mentioned in 10.8. The court shall also record its satisfaction as to the clarity, sound and connectivity for both court users and remote users. On the 10.9 specifically provides on the completion of video conferencing, if a remote user believes that she or he were prejudiced due to poor video and audio quality, as I said earlier, then it need to be immediately informed. The provision is extended even to the cases where an accused is to be produced before the court for either the judicial remand or the police custody, except at the first occasion. On the first occasion, it is desirable, unless and until prevented by extraordinary circumstances, that the accused should be produced before the court physically. For obvious reasons, all the criminal lawyers would know why it is so. However, after that, from the judicial custody, through the further link, through the concerned superintendent of jail, the remand period can be extended, or whatever the decision that the court has to take. 164 statement, except only in the exceptional circumstances, need not be recorded. That is what it says. It also says 11.2 that the court shall ensure compliance with section 26 of the Evidence Act. Now I'll just immediately take you to the last part of this. Which is the general procedure, chapter number 4. In 12.4, it is stated that in civil cases, parties requesting for recording of statements of the person to be examined by video conferencing shall confirm to the court the location of the person, the willingness of such person to be examined through video conferencing, and the availability of technical facilities for video conferencing at the agreed upon time and place. .8 is very important from the criminal trial perspective, which I am reading in full. If the accused is in custody and not present at the court point, the court will order a multi-point video conference between itself, the witness, and the accused in custody to facilitate the recording of the statement of the witness, including medical or other experts. The court shall ensure that the defense of the accused is not prejudiced in any manner and the safeguards contained in the rules are observed. Then 13 is the cost of the video conferencing. 14th is the conduct of proceedings. And it also provides about access to legal aid clinics, camps, local adalats. So, all my colleagues who are in the legal aid panel should also go through it very minutely. The last part of this video is that this is the first time it is stated when a witness is unable to come to a remote point and give his testimony. Then the court can direct the coordinator at the remote point to go to the witness and record the things if it is causing delay and causing otherwise obstruction to the advancement of the cause of the justice. So not only this has allowed a seamless movement in times to come, and which of course it will be tested, but it has gone a step further from the long drawn experience of the honorable judges of the High Court, that there are certain witnesses because of whom the trials are held up for years, affecting the accused, their liberty, their everything, and therefore it is provided that the entire setup can go to the house, and whatever the cost, the state would bear it, the party would bear it, but the quest for the justice would not be affected. I do not say even for a moment, nor I wish to believe that this is a way to dispense with the actual traditional legal court system. However, unprecedented times call for unprecedented measures, and those who rise during the times of the adversity makes a great impression. I must also add these rules are far better than the practice which is done in various other countries, such as, from my personal experience, Australia, where still they follow a queue system by way of a audio recording and then dispensing with the justice. I am not saying that they are wrong or they are not doing as good as what we are doing. They have done earlier. I am sure they would be looking up to India and many other countries and the Delhi High Court, true to its reputation, and much to my relief, with due respect, I say, has far lived up to and way beyond the expectation. Thank you very much. Grateful.